Good morning, Alex and friends. I'm Grace. Today is Saturday, December 13th, 2025, and you're listening to Alex's News. The high in Riverside today is 78.1 degrees, with a low dipping to 55.5 degrees, so expect a pleasant but cooling evening ahead. Coming up on the show, we'll examine the Department of Justice's efforts to halt a judge's contempt investigation tied to deportations from the Trump era, and break down how new fees on H-1B visas are preventing California schools from recruiting international educators. We'll also cover other key developments from around the nation and the world. All this and more coming up on Alex's News. Stay tuned. It's a fast-moving legal fight over Venezuelan deportations and a judge's contempt probe. Our justice correspondent Ethan is here to break it down. Ethan, what changed late last night?
The Justice Department rushed to the D.C. Circuit with an emergency request, and the appeals court hit the brakes. According to the Associated Press, which was picked up by the Los Angeles Times and Yahoo News, a three-judge panel granted a temporary administrative stay late on December 12th. That pauses Chief Judge James Boasberg's contempt inquiry for now, just as witness testimony was set to start as early as tomorrow, December 14th. It doesn't decide the merits, but it stops the proceedings in their tracks.
What's this contempt inquiry about in the first place?
It stems from a March operation where the Trump administration used the Alien Enemies Act, a centuries-old wartime law, to deport more than 250 Venezuelans it described as gang members. On March 15th, during an emergency hearing, Judge Boasberg issued a temporary restraining order and told government lawyers to get planes already en route turned around so the men could challenge their removals. The flights kept going, and about 137 men were offloaded in El Salvador and sent to the CECOT mega prison. The Washington Post and the Boston Globe have documented allegations from families and rights groups that men were shaved, forced to march, and possibly tortured without hearings.
Why was the Alien Enemies Act used here?
The administration argued that Tren de Aragua, a Venezuela-based criminal network, constituted an invasion or predatory incursion, triggering the 1798 statute. President Trump formally invoked the law on March 14th, after designating Tren de Aragua, alongside MS-13, as a foreign terrorist organization in January. The Alien Enemies Act allows detention and removal of so-called enemy aliens without the usual due process protections, which is why it's rarely seen in peacetime. AP reporting, syndicated by CBS News, also notes the U.S. paid El Salvador about $6 million to take the deportees into CECOT, a facility notorious for harsh conditions.
So what exactly did the judge order, and where's the supposed confusion?
Boasberg gave an oral order on March 15th to return the planes immediately, then followed with a written TRO. DOJ argues the oral instruction wasn't fully mirrored in that first written order, creating ambiguity about what had to happen and when. The department points to cases like United States versus United Mine Workers, saying criminal contempt requires clear, specific notice under Rule 65, and ambiguities should be resolved in favor of the accused. Legal analyses in the Washington Post and Justia note that while oral bench orders are generally binding, discrepancies between oral and written directives can muddy contempt liability.
How did we get from that to probable cause for contempt?
By April 16th, Boasberg said he saw probable cause that officials acted in bad faith by rushing ahead and offering, in his words, unsatisfactory explanations. He wrote, quote, "The Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to uphold it," end quote. He then opened a formal inquiry in November to decide whether to refer the case for criminal prosecution under the court's contempt statute, 18 U.S.C. Section 401. A D.C. Circuit panel in August had paused some contempt-related demands due to confusion in the orders, but Boasberg read a November decision as affirming his power to keep investigating.
Who was expected to testify, and why did those appearances matter?
The most anticipated witness was Erez Riveni, a former DOJ attorney turned whistleblower scheduled for tomorrow, December 14th. He's alleged, according to coverage echoed by CBS News, that a senior DOJ official suggested the government might have to ignore court orders, saying those planes need to take off no matter what. On Monday, December 15th, Deputy Assistant Attorney General Drew Ensign was set to testify about how the orders were conveyed to Homeland Security. DHS Secretary Kristi Noem filed a declaration saying she acted on privileged legal advice, but Boasberg called that submission cursory and inadequate to assess willful defiance, as the Washington Post reports.
And DOJ's filing yesterday took a pretty aggressive tone?
Very much so. The department called the probe a radical, retaliatory, unconstitutional campaign and accused Boasberg, an Obama appointee, of turning it into a circus that tramples separation of powers and attorney-client privilege. They urged the appeals court to stop the hearings and remove the judge to avoid, in their words, unseemly and unnecessary interbranch conflict. They also renewed their argument that the March 15th Return the Planes directive was only oral at first, and not clearly captured in the initial written order, making contempt improper.
What did the appeals court actually do with that?
The panel issued a per curiam administrative stay, which is procedural and unsigned, and it freezes Boasberg's contempt-related orders for the moment. The Associated Press and the Los Angeles Times both note the panel includes 2 Trump appointees and 1 Biden appointee, the same mix that handled an earlier phase. Importantly, the stay doesn't say who's right. It just pauses testimony and document demands while the judges consider next steps. As of this morning, there's no public order canceling tomorrow's hearing, but the stay casts real doubt on whether any witness will be sworn.
Stepping back, how solid is the claim these men were gang members?
Independent verification is shaky. Bloomberg's investigation, cited by CBS News and Mother Jones, found 90% of the deported men had no U.S. criminal records beyond minor violations, and some so-called evidence looked like misread tattoos of soccer clubs or religious symbols. Many families and lawyers say these men were fleeing Tren de Aragua, not part of it, and had sought asylum. An April National Intelligence Council assessment, reported with the caveat that the FBI dissented, concluded there wasn't evidence of coordination between the gang and Venezuela's Maduro regime.
But Tren de Aragua is a real group, right?
It is, and law enforcement takes it seriously. The network grew out of Venezuela's Tocoron prison and is blamed for extortion, trafficking, and exploiting migrants along routes into the U.S., according to the Washington Post. The Biden administration sanctioned the group in 2024, and the Trump administration escalated by labeling it a foreign terrorist organization in February 2025. That said, experts interviewed by NPR and The Post describe it as a loose, decentralized network rather than a unified army that would typically trigger wartime authorities.
How have other courts handled the Alien Enemies Act argument this year?
In Texas, a federal judge permanently enjoined the policy on May 1st, calling it unlawful, according to AP. Then on September 2nd, the Fifth Circuit held in a 2-1 ruling that, as NPR summarized, mass immigration isn't an invasion under the Constitution. The Supreme Court briefly stepped in on April 19th to pause some deportations, but later allowed very limited use conditioned on due process safeguards. So the trend in the courts has been skepticism about broad, peacetime reliance on this 18th century law.
What does the DOJ say about separation of powers and privilege here?
DOJ argues the judge is intruding on internal executive deliberations by demanding testimony about advice and communications protected by privilege. Their emergency filing warned that continuing would force disclosure of attorney-client communications and chilled policy discussions, claims the Washington Post says are likely to be tested if the stay lifts. Officials frame it as a structural clash, courts policing executive enforcement versus executive confidentiality. And they say the court's contempt power must be used sparingly because it's criminal in nature.
You mentioned Boasberg rejected a request to cancel hearings yesterday.
He did, before the appeals court intervened. He wrote that this was not some academic exercise given the suffering reported by the men and their families. According to the Post, he saw the inquiry as necessary to determine whether officials willfully defied a lawful order and whether a criminal referral is warranted. That framing emphasizes the judiciary's role in enforcing its own orders, even against powerful actors.
There's also political heat around this judge, isn't there?
Yes, and it's unusual. Back in March, President Trump publicly called for Boasberg's impeachment, which NPR noted as part of a larger pattern of attacking judges in immigration cases. In July, DOJ filed a misconduct complaint against him, alleging improper comments about Trump, though the details haven't been fully aired in public filings. Attorney General Pam Bondi has also blasted the judge on social media, calling his actions lawless judicial activism and promising, quote, "it will not stand," end quote.
What's the human situation for the deported men right now?
Families say contact is sporadic, and some fear their relatives have been beaten or worse inside CCOT. The Globe and the Post have reported accounts of shaved heads, forced marches, and punishments without legal process. Lawyers are trying to press claims from afar, but it's difficult when the men are in a maximum security facility in another country. The bottom line is, the human toll is part of why the judge insists this isn't theoretical.
What are the next steps after last night's stay?
The appeals court will likely set an expedited schedule to decide whether to keep the stay in place while it weighs the DOJ's bid to shut down the inquiry or reassign the case. That could come in days, not weeks, given the planned testimony dates. If the stay is extended, Rejuvain and Ensign won't take the stand next week. If it's lifted, Boasberg has signaled he's ready to proceed quickly.
Could this end up at the Supreme Court?
Absolutely. Either side could ask the full D.C. Circuit to step in, and from there it's a short path to the Supreme Court, especially with separation of powers claims on the table. The justices have already brushed up against this issue once this year with that April emergency order. If they take it up again, they'll be weighing not just immigration policy, but the clarity required for contempt and the limits on judicial oversight of executive enforcement.
And the core legal question here?
Two, really. First, whether government officials clearly violated a court order, given the alleged mismatch between the oral and written directives on March 15th. Second, whether a district judge can probe that potential violation in a way that brushes up against privileges and interbranch comity. The D.C. Circuit's stay leaves both questions open, and as the Washington Post put it, preserves the status quo while the judges sort out the ground rules.
How unusual is it for DOJ to try to remove a sitting judge from a case like this?
It's rare, and it's a high bar. DOJ is essentially arguing Boasberg's conduct shows bias and has turned the proceeding into an unfair process, which, according to legal scholars quoted by NPR, is tough to prove without clear evidence. The appeals court could reassign the case if it finds even an appearance of partiality, but courts are cautious about that. Most often, they narrowly tailor relief rather than ousting a judge.
If the hearings do resume, what would you watch for?
Whether Rejuvain confirms that anyone instructed agencies to ignore a court order, and how DOJ counters that narrative. I'd also watch if the court compels testimony over privilege objections, especially from senior officials like Secretary Noem or top lawyers, and how narrowly Boasberg frames questions to avoid intruding on court deliberations. Finally, I'd look for any documentary trail, emails, or memos showing what directives went out as those planes were in the air.
Where does this leave the broader immigration agenda?
Just showcase fight. NPR and AP have described a year of sweeping actions, tightened asylum rules, and deportations to countries like Ghana and Somalia that courts have repeatedly tested. This contempt probe, now on pause, becomes a proxy for whether judges can meaningfully check the executive when it claims emergency authority. However it ends, it will shape the boundaries for immigration enforcement in 2026.
Ethan, thanks for walking us through it. We'll keep following the appeals court's next move. California schools say a new federal fee is choking off their pipeline of foreign teachers. Chloe, bring us up to speed on what changed and why it matters right now.
The Trump administration imposed a $100,000 sponsorship fee on new H-1B petitions this fall, and it took effect on September 21st. The White House frames it as protecting U.S. workers and stopping wage suppression, but California's districts say it's gutting their ability to fill critical teaching roles. CalMatters, republished by LAist yesterday, reports that the fee sits on top of the usual $9, $500 to $18, $800 in visa costs, which cash-strapped districts simply can't afford. It's hitting hardest in special education and dual language immersion programs that rely on internationally trained educators.
How bad is the teacher shortage in California before this fee?
It's been severe for years. The state recorded nearly 47,000 misassignments, meaning people teaching outside their credential, and more than 22,000 vacancies in 2023, according to the California Commission on Teacher Credentialing. Close to 28% of those gaps are in English language development, serving roughly 1.1 million multilingual learners, while about 12% are in special education. The Learning Policy Institute has noted districts increasingly bring in credentialed teachers via J-1 exchange visas and then shift to H-1Bs to keep them longer, precisely because domestic candidates are scarce.
So the H-1B route was a pressure valve. How many schools used it recently?
The California Department of Education saw over 300 H-1B applications from districts in the 2023-24 school year, roughly double from 2 years earlier. CalMatters reports that in 2024 alone, 294 public school teachers were hired in California under H-1Bs, with many coming from the Philippines, Spain, and Mexico to fill bilingual and special education roles. Nationally, educators make up a sizable slice of H-1B users, nearly 30,000 by some counts, cited in the CalMatters piece. Those numbers underscore how integral this pathway has become to keeping classrooms staffed.
Who's waving the red flag inside the districts?
West Contra Costa Unified is a striking example. The district had 381 misassignments and 711 vacancies in 2023, and it's counting on 88 H-1B hires focused on special education and dual language positions, CalMatters reports. Assistant Superintendent Sylvia Greenwood described those hires as highly skilled lifelines, but the district has ongoing budget shortfalls and no clear way to pay the new fee. Their superintendent, Cheryl Cotton, called it very difficult for any district, and the union president warned students would see greater instability, with special ed, he said, already on fire.
Are other districts changing course because of the price tag?
Yes, especially those in deficit. Pasadena Unified, facing a $27 million shortfall, filed about a dozen H-1Bs in 2024, but now expects applicants to shoulder the $100,000 fee and has stopped covering legal and immigration costs, according to spokesperson Hilda Ramirez-Horvath, cited by LAist. Los Angeles Unified said as of mid-November it hadn't seen immediate hiring impacts, but their spokespeople told CalMatters immigration experts are assessing longer-term fallout. Meanwhile, United Teachers Los Angeles criticized what they called a lack of guidance for staff, helping H-1B applicants navigate the changes.
What do affected teachers say this means for their lives and classrooms?
The human toll is stark. One West Contra Costa High School teacher, identified as HR, came from Mexico on a J-1 and missed the H-1B deadline. His visa expires in June 2026, and without district support, he can't afford the process. He told LAist reporters Sophie Sullivan and Alina Ta, quote, "Everybody says here that they need teachers, but they don't want to do anything to help us stay," end quote. Another teacher from the Philippines, referred to as AF, said the new fee felt like a form of discrimination after his district previously covered just a fraction of costs.
What happens to families if bilingual programs shrink or disappear?
Parents are worried. A Richmond parent, Killeen Peckham, told LAist, the Spanish immersion program at Washington Elementary helps her kids connect with their Mexican relatives, and she'd consider pulling them out if staffing shortages end the program. Advocates argue this isn't just about teacher headcount. It's about maintaining multicultural education that supports families across languages and cultures. The Justice Action Center told LAist, the fee is like a giant keep-out sign, signaling that even vital educators aren't welcome.
Let's talk mechanics. Who exactly has to pay this fee under the new rules?
USCIS and DHS guidance published in late October clarifies that the fee applies to most new H-1B petitions, especially when consular processing is involved, even if the person is physically in the U.S. at filing. Change of status petitions for people already here, like a J1 teacher switching to H1B without leaving the country, often escape the fee as long as they maintain lawful status and don't travel before the case is decided. Prior filings before September 21st and extensions for existing in-country H1B workers are exempt. But there's no broad carve-out for K-12 districts, special education, or dual language roles, according to USCIS FAQs and analyses by immigration firms K and L Gates and Holland and Knight cited by CalMatters.
Are there any ways around it for schools?
There are narrow, uncertain options. DHS says a national interest exception could waive the fee in extraordinarily rare cases if districts prove there are no available U.S. workers, no security concerns, and that a waiver benefits the country. Petitions need to be filed through a DHS email box, and payment must otherwise be made upfront through pay.gov or the application gets rejected. CalMatters reports no teacher-specific exemptions have surfaced, so districts are left hoping for case-by-case mercy or looking back to shorter-term J1 programs that can't fully replace H1Bs.
How are schools paying when they can't pass the cost to teachers?
Many simply can't. And that's the crisis. West Contra Costa told CalMatters it's unclear who should shoulder the fee, the district, the teacher, or a third-party backer, and those conversations are now happening amid budget deficits. Some, like Pasadena, have shifted the cost to applicants, but that changes who can even apply, effectively closing the door to many qualified educators. LAist frames it as a choice between keeping programs alive or accepting larger class sizes, more misassignments, and closures.
What about statewide finances? Does this collide with broader budget trouble?
Absolutely. The Fiscal Crisis and Management Assistance Team, or FCMAT, aggregated reports this week showing districts across the state, from Long Beach to San Diego, are dealing with structural deficits. That leaves very little cushion for unexpected six-figure fees per hire. EdSource coverage picked up by FCMAT warned the fallout could be devastating if no exemptions are created for teachers. When you add the fee to existing fiscal pressures, bilingual and special ed programs are first on the chopping block.
You mentioned this kicked in September 21st. Were districts caught flat-footed?
The proclamation was signed September 19th and became effective just 2 days later, which created immediate uncertainty. USCIS updated FAQs through the fall, but CalMatters notes the guidance hasn't offered much relief for educators. Districts in the middle of recruiting were forced to decide whether to pay, delay, or abandon hires. That's why some teachers, like HR, missed windows they were counting on.
What's the administration's case for doing this?
The stated goal is to prioritize American workers and prevent downward pressure on wages, a long-running critique of H-1B by restrictionist policymakers. The White House argues employers should first raise pay and invest in domestic training rather than rely on visas. But school districts point out that teaching shortages, especially in special education and dual language, are well documented and persistent, with too few domestic candidates. CalMatters underscores that districts aren't trying to save on wages. They're trying to fill seats with credentialed teachers who can serve specific student needs.
Are there legal challenges to stop or suspend the fee?
Several. Yesterday, California Attorney General Rob Bonta led a 20-state coalition suing in federal court in Massachusetts, arguing the fee violates the Constitution and Administrative Procedure Act by raising revenue without Congress and bypassing notice and comment. The U.S. Chamber of Commerce filed a separate suit claiming the policy conflicts with the Immigration and Nationality Act and harms employers nationwide. And a Justice Action Center-led coalition, joined by unions like the United Auto Workers and the American Association of University Professors, filed in San Francisco shortly after the proclamation. Courthouse News Service and CalMatters say no hearings are set yet.
Any injunctions or relief on the horizon?
Not yet. As of this morning, there are no hearings or injunctions in place, so the fee remains fully operational. Districts are in limbo, waiting to see if courts will pause the policy or if DHS will carve out limited exemptions for sectors like education and healthcare. In the meantime, recruiting cycles are slipping, which could ripple into next fall's staffing, according to LAist.
How big could the ripple be for special education specifically?
It's potentially severe. Credentials issued in special education dropped by almost 600 from 2020 to 2024, and districts filled the gap with a 300% spike in temporary permits, according to the Commission on Teacher Credentialing data cited by CalMatters. Those workarounds carry higher burnout and turnover, and international hires often stabilize teams by bringing specialized training. Without that pipeline, experts warn of heavier caseloads, compliance risks, and more program closures, particularly in high-need districts.
What about English learners and dual language programs?
The stakes are high for multilingual learners. Nearly 28% of staffing gaps are in English language development, and dual language immersion programs rely disproportionately on teachers who are fluent, credentialed, and culturally competent. CalMatters and LAist highlight that losing these educators destabilizes programs that boost literacy and family engagement for 1.1 million students. Parents, like the Richmond mom we mentioned, see it as a direct hit to their kids' ability to learn and connect with relatives.
Could districts just lean more on J-1 visas instead?
Some are considering it, but it's not a one-for-one substitute. J-1s are exchange visas meant to be temporary, with tighter limits and rules that can restrict long-term stability in classrooms, the Learning Policy Institute notes. Districts have used J-1s as a bridge to H-1Bs, but if the bridge collapses, they're back to short-term placements and constant turnover. That churn is tough on students, especially those with special needs or learning English.
You mentioned payment logistics. How rigid is the process?
Very. DHS requires the $100,000 fee to be paid before filing through pay.gov, and USCIS will deny petitions if it isn't. That leaves little room for fundraising or piecemeal payments, and districts can't submit and hope to settle later. CalMatters reports that even cap-exempt employers like public schools aren't spared, which is part of why administrators describe the fee as prohibitive.
What are advocacy groups asking for in the short term?
They want teacher-specific exemptions, or at least a targeted national interest pathway for education and healthcare, where shortages are well documented. EdSource and CalMatters both note that advocates argue the president's broad entry restrictions shouldn't be used to re-engineer the H-1B program for critical public services. In their San Francisco suit, the Justice Action Center Coalition says entry limits can't nullify Congress's H-1B framework for sectors like education and medicine. Until there's a ruling or policy tweak, they're also urging districts to prioritize change of status filings to avoid the fee when possible.
And for families listening, what should they watch over the next few weeks?
Keep an eye on the early court dockets for any motions for emergency relief in those lawsuits filed yesterday and earlier this fall. Districts will also update school board agendas with staffing reports for spring hiring, which could hint at program cuts or preserved positions. LAist and CalMatters have been tracking this closely, and USCIS continues to update FAQs, though educator-specific relief hasn't appeared yet. If your child is in special ed or a dual language program, ask principals about contingency plans as hiring decisions for next year ramp up.
Final thought. Chloe, what's the bottom line for California classrooms?
California built a fragile, necessary pipeline to bring in credentialed teachers where shortages are most acute, and the new fee punches a hole in it. According to CalMatters, districts that doubled down on H-1Bs in recent years now face an unaffordable bill that could undo gains for English learners and students with disabilities. Personal stories like HR and AF bring home that this isn't abstract. Families could be uprooted, and kids could lose the teachers who understand their needs. With no injunction as of today, the policy is in force, and the next few weeks will determine whether courts or DHS offer any lifeline to keep classrooms staffed.
Clear and urgent reporting, Chloe. Thanks for walking us through it. Here are some other headlines. Washington is awash after historic rains from a potent atmospheric river turned the evergreen state into ever wetter. Rivers crested at record levels, forcing dramatic rooftop and vehicle rescues from Sumas to Burlington to Mount Vernon. Governor Bob Ferguson declared a statewide emergency, confirmed by the White House, as National Guard troops and Coast Guard crews pulled dozens to safety. Levee breaches and landslides snapped critical links, with Interstate 90 among the major arteries clogged by nature's gridlock. Officials warn water levels will stay dangerously high for days, with another storm on the horizon. It's a flood of concern for infrastructure in key farm and bedroom communities, commerce sidelined, thousands displaced, and the region reminded that when it rains, it pours policy questions about climate resilience. Wall Street's worry lines are deepening as corporate bankruptcies in the U.S. surge toward a 15-year high. Fueled by heavy debt loads and interest rates that refuse to take a rate bow, companies are finding it harder to keep the lights on as consumer spending dims. NYU's Edward Altman told NPR's Weekend Edition that distress levels rival the 2010 shadows of the Great Recession. With filings rising in double digits year over year, it's a sobering balance sheet. When the cost of money goes up, fragile firms go down, and the trend is more liquidation than lemonade. A nationwide alert for parents. Federal officials say a botulism outbreak tied to ByHeart baby formula has sickened at least 51 infants across 19 states, with all cases requiring hospitalization. The FDA and CDC expanded their investigation back to December 2023 and say they cannot rule out contamination across the brand's entire production history, covering all whole nutrition infant formula cans and single-serve, anywhere packs. A total recall first issued in November remains in force. The CDC calls the scope unprecedented, a gut punch to families relying on organic options. Expect tightened inspections and long-term scrutiny of production practices. Because when safety is on the bottom line, regulators don't soft pedal. A legal tug-of-war over voter data is tightening. The Department of Justice, led by Attorney General Pam Bondi, filed federal lawsuits against Colorado, Hawaii, Massachusetts, and Nevada, demanding detailed voter registration rolls that include driver's license numbers and partial Social Security numbers. The DOJ says it's essential for enforcing the National Voter Registration Act and weeding out non-citizen voting. State officials call it an overreach with privacy pitfalls. Massachusetts Secretary Bill Galvin labeled it intimidation, while Colorado's Jenna Griswold says her office won't hand over sensitive voting information to Donald Trump without a clear legal mandate. With 18 states now in the courtroom, the clash sets the stage for a midterm season stress test of federal power versus state control. Data or it didn't happen, say the feds. Data and it shouldn't happen, counter the states. And in Brussels, the EU just put Moscow's money on ice, indefinitely. About 210 billion euros in Russian central bank assets remain frozen under Article 122 emergency powers, a move that sidesteps Hungary and Slovakia's veto leverage. The freeze underwrites a planned 165 billion euros loan package for Ukraine through 2027, aiming to lock in aid as the war grinds into its fourth year. Budapest and Bratislava blast it as illegal. Moscow threatens payback against Euroclear, the Belgian clearinghouse holding most of the funds. For Kyiv, the decision is financial armor. For the EU, it's unity by emergency design. No revolving door on sanctions, just a deadbolt. That's all we have for now. Today's episode was made by Alexander King with GPT-5, Gemini Pro 3, Gemini Flash 2.5, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.